Hi, everyone. Welcome to another edition of CCK Live. My name is Mike Lestrito, and today I'm joined by Michelle DeTore and Elise Phillips to discuss common mistakes veterans make when filing VA claims for increased ratings. So, to begin with an overview of VA ratings, when a veteran applies and is ultimately granted VA service connected disability benefits for a particular condition, VA assigns a disability rating for the condition based on the severity and impact on the veteran's earning capacity. These ratings are assigned based on VA's what's known as Schedule for Rating Disabilities, which assigns a particular rating, VA rating, based on specified symptoms that the VA is looking for to assign a particular rating. These ratings can range from a 0%, what's known as a non-compensable rating, all the way up to the max scheduler rating of 100%. And typically, the increments range in 10% increments. So a rating from 0 to 100 qualifies the veteran for monthly compensation. 0% obviously being a service-connected condition that unfortunately does not result in any monthly compensation, but is nevertheless service-connected or related to service, and 100% rating providing the max rating allowed, at least for a scheduler rating. Ultimately, as I'm sure you can suspect, a higher rating equals more monthly compensation. So with that very brief background in mind, Michelle, I'm going to turn it over to you. Can you talk to us a little bit about what are claims for increased ratings of a service-connected condition?
So anytime that veteran believes they are underrated, they can either file or appeal for an increased rating for their condition. So how you do that is it depends on kind of where you're at with your case. So if you're within a year of a rating decision that denied or granted service connection and you didn't think that the rating was high enough, you would appeal. At that point in time, you can either, usually in the AMA system, which is the Appeals Modernization Act, you can file a supplemental claim appeal on a VA form 0995. You can file a higher level review appeal on a VA form 0096, or you can file directly to the board on a notice of disagreement, which is a VA form 10182. If you're outside the 1 year window, then you're going to be filing a new claim for an increased rating, which is typically going to be the VA form 526. However, sometimes it still might be the supplemental claim form, just depends on kind of the case and scenario. Again, it gets a little confusing with the forms, but you would be filing there for an increased rating for the condition. So kind of what do you need to support it, or what do you need to do in order to file is you typically would want to be submitting evidence that supports that your disability has worsened or was underrated. It can be treatment records, it can be statements, it can be even a VA examination that supports a higher rating. Keep in mind, anytime you usually submit a claim or an appeal for an increased rating, VA will typically always schedule a VA examination. So a lot of times you will have that going on as well. It just depends also on what type of lane that the appeal is gone in, because keep in mind the duty to assist is not in every appeal lane in the Appeals Modernization Act. So if you went higher level review or certain board review lanes, unfortunately, it doesn't always require an examination, or examination will not be submitted. But if you do have evidence and your election for appeal does allow for you to submit evidence, those are some things that you would want to do is, get maybe a private medical opinion, or you could go out and get your own medical records or something that supports your increased rating.
Yeah, and so this is a big change from the old appeals processing system potentially, right? So in the old system, prior to February 19th, 2019, commonly referred to as the legacy appeal system, veterans could submit evidence at any point in time to support their increased rating claim or appeal. And Michelle, now in the new appeal system, the AMA system that you alluded to, there are very specific periods when veterans can submit, lay statements, as you alluded to, medical records, or other evidence. And so I think it's right. It's really worth veterans understanding the different appeal options that they have in AMA and when they cannot submit evidence in support of their increased rating claim or appeal.
Yeah, it's very confusing, and it's limiting in a lot of ways. But this is when with this appeal system, we always find that it's very helpful to reach out to somebody that knows, when and how and what's the best course of action based on, especially something like this where you're trying to demonstrate that your disability has worsened. You want to be able to submit evidence at that point in time. So sometimes you want to be able to talk to somebody to see what's the best way to go in order to be able to do that.
Yeah, exactly. And that leads into our next topic here, Elise, common mistakes veterans make when filing for increased ratings. So there are a number of different potential pitfalls that veterans can unfortunately fall into. Can you walk us through a couple here to start?
Absolutely. So the first one is going to actually kind of bounce off what Michelle was talking about, and it's going to be not appealing an increased rating decision. Whether you're granted an increased rating that you think you should be granted a higher one, or you're just denied an increased rating. You do have a right to appeal an unfavorable decision from the VA. And it's important that if you are still within a certain time period, which is, under the year, in most cases, that you should file an appeal rather than a new claim. The reason for that being that you'll be able to preserve your claim stream. Your effective date will go back to when you initially filed your claim. If you file a new claim, it might mess up your effective date. Sometimes it can really muck up your whole claim stream if things aren't filed on the proper form. So going back to what we were talking about, really important to have assistance there. Sometimes we'll see veterans file things on the wrong forms. They'll be intending to file an appeal, but they're actually filing something on a new claim form. VA will accept that as a new claim and change their effective date. So it is really important to be careful with the forms that you're using. And if you are within the appeal period, to actually appeal, not file a new claim. Going off that, another thing that we see is people will wait to file their claim. So basically they'll miss that date, that effective date. Be very careful when you do have either, but when you're appealing, just make sure that you are filing that within the 1 year. Again, like I said, if you don't, it will mess up your effective date.
Yeah, and so it seems in my mind to be, you can break it down into two ways of thinking about it, right? If there's a decision that a veteran receives that is, you're still within the 1 year period to appeal the increased rating, veterans should file the appeal rather than submitting a new claim for that same condition. If veterans are outside of the 1 year period to appeal either a denial or a grant that they're not satisfied with for the increased rating claim, so they unfortunately cannot appeal, then they would file a new claim. And I think what we have all seen in our practice is that the sooner you file, the better, and in order to lock in that effective date. And one mechanism in order to do that is to file an intent to file form, which is a specified form that VA has. Veterans or veterans advocates can file the form. They don't have to necessarily even specify the type of claim that they're going to file at that time, but that form in and of itself locks in the effective date as of the date that the veteran files the intent to file, so long as the veteran ultimately ends up filing the claim within 1 year of the intent to file. So, waiting to file a new claim, if that's what is in fact is needed, could result in a loss of retroactive benefits for months or years potentially, even if the veteran ultimately has their claim granted. So that's a very common, you're right, Elise, that's a very common mistake that we unfortunately see all the time in our practice here. Another common mistake that I see is the failure to obtain sufficient medical evidence or a medical opinion. So VA often denies increased rating claims or appeals based on the fact that it finds that there's a lack of medical evidence specifically demonstrating the severity of the condition and or how the disability has worsened. So therefore, a medical opinion from either an independent expert or even a letter from a private healthcare provider that the veteran can obtain and then submit can really make a huge difference in helping to support and ultimately have your claim granted. Veterans often make the mistake of relying on the results of simply a compensation and pension examination, so in other words, a VA exam. It's really important to rebut any unfavorable findings that may exist in a compensation and pension examination with your own medical evidence. Again, whether that's a private treating physician that can write a letter for you. Maybe that individual has known you and examined you for a long time. They can state as much in the letter. Or an independent expert in some situations can really be helpful as well. Those individuals, particularly private healthcare providers, often know the veteran and can speak to all the reviews and examinations that they provided to the veteran in the past. And oftentimes VA, at least we would argue, should find that evidence is much more probative, much more important to consider when examining the veteran's condition or the severity of the veteran's condition than one compensation and pension examination that occurs at one moment in time, perhaps for 10 to 15 minutes, without a thorough review of the file. In a similar vein, another mistake that we see very frequently, unfortunately, is that veterans do not attend their compensation and pension examinations. So although we want to rebut unfavorable findings if they do occur in compensation and pension examinations, like we were just talking about, it is ultimately very important that veterans do attend these exams. Why? Because if a veteran doesn't attend a compensation and pension examination, it's very low-hanging fruit for VA to swoop in and deny on the sole basis that the veteran did not attend the exam. Oftentimes, in a lot of decisions that I've seen, the VA won't even cite any other evidence. They'll just say, nope, we scheduled you for an exam, you didn't attend, I'm sorry, we're denying your claim. So don't let that happen to you. We want to make sure that we're attending all of our CMP exams, and then even if it's unfavorable, we will have ways, or your representative will have ways to potentially address those unfavorable findings, but it is important that veterans attend in the first place. Another thing on the topic of compensation and pension exams is veterans are entitled to a copy of the exam. And so the report may not be done the same day, even the same week, perhaps even the same month, unfortunately, as the date of the exam, but ultimately veterans advocates representing the veteran are entitled to a copy of the exam, and I would really recommend that veterans or accredited agents or attorneys request a copy of the exam so that they can see specifically what the findings were and how to rebut them. Michelle, turning back to you, can you tell us a little bit about the submission of evidence that either is unhelpful or is just irrelevant to a veteran's claim?
Yeah. So I think sometimes we see where the evidence isn't submitted that supports the increased rating or showing that the increased rating. And I think sometimes the confusion is what is the issue at this point. So sometimes, you've been fighting so long for service connection, you get service connection, and I think it's hard to realize that at this point now you're switching, like VA's granted service connection. Now the issue is no longer whether or not the condition is related to service. The issue is the severity of the condition. So sometimes clients will be resubmitting service records, resubmitting all this evidence showing that the condition is related to service, when at this point in time, that's no longer VA's problem or VA's issue with the claim or appeal. Their issue is that they don't believe that the increased rating is warranted, or they believe that they've given the proper rating. So at that point in time, the issue now becomes finding records that show that increased rating. I think sometimes you also see where clients submit all their medical records, where you end up submitting hundreds and hundreds of pages of medical records that maybe don't have to do with this condition. So, you'll say, I treat here, here's all my VA medical records. And like that's great. And that's definitely what you should be doing in some cases, but sometimes it buries the relevant evidence in thousands and thousands of pages of unrelevant evidence. So it's hard to find those pieces of evidence that support the increased rating. In those circumstances, what I would usually tell a client is, let's find the doctor, let's find the records that show the increased rating, and that's what we want to be submitting. We can also obviously tell them where you're treating, tell them to get those records, but we want to highlight the records that support the increased rating. So we want to make sure we're submitting that. I also think that sometimes going along with, submitting the proper evidence, it's also knowing what actually entitles them to an increased rating, which can be difficult because now you're talking VA regulations, VA rating criteria. And sometimes that information is not always very comprehensible. Sometimes they're talking about ejection fraction rates and medical terms and stuff that maybe, people aren't as familiar with. So it's very hard to know. So I think that it's also going along with the lines of, what evidence to submit is also knowing kind of how you're going to get to that increased rating. And unfortunately, some cases, the condition might be worse and you might feel worse than, the 10% rating or the 20% rating that you got. But unfortunately, VA's rating criteria is very strict in the sense that you're just not going to get that increased rating up to, the 30 or the 40, based on, the additional pain because they require, X, Y, and Z instead. So I think that that's something also to be very mindful of is, knowing if you are entitled to the next highest rating based on the rating criteria. And that's, again, when, reaching out to somebody, reaching out to an accredited representative, an attorney, a VSO, somebody that could help you, understand if you're unclear on the rating criteria as well.
Yeah. And so the bad news is that the rating criteria is often complex. It changes frequently. It's difficult to understand and then difficult to apply. The good news, though, Elise, is that there's help out there for veterans, right?
Absolutely. And that brings us to our last common mistake, which is failing to seek assistance from a representative. We see, especially now with the new implementation of the AMA, the VA disability claims process is it's such a complex system with regulations, procedures, forms, requirements that are expected of a veteran to be able to get their increased rating, that it is very helpful to have someone who is knowledgeable and can help you kind of just guide through the weeds a bit, help you with knowing which forms to file, whether you should be filing an appeal or a new claim, help you gather the medical evidence that you might need or lay evidence that you might need to get that increased rating, and also just what type of evidence really VA is going to be looking for. So an accredited representative can help you gather all of that. And their experience is going to really help ensure that you get the benefits that you deserve.
All right. Well, thank you both. That's all that we have for you today. For more information on increased ratings and increased rating claims and appeals, check out our other YouTube videos. And as always, be sure to subscribe to our channel and follow us on social to keep up to date with the latest veteran-related news. As always, thank you for joining us.